LawSikho's thorough newspaper analysis for 20th Feb 2023. Starting with the editorial section of today's session, the curious case of the disqualification of a politician from The Hindu, followed by the news update and the legal news. The editorial part of today's session, the curious case of the disqualification of a politician, the Honorable Kerala High Court suspension of Kavarati District and Session Court's verdict sentencing Mohammad Faisal being sentenced to 10 years in jail is a curious case of disqualification. Previously, Mr. Faisal was convicted by the Kavarati Sessions Court on 11th January 2023 for attempt to murder and sentenced to 10 years of imprisonment. Based on this conviction, the Lok Sabha disqualified him as an MP. The question that remains is whether Mr. Faisal shall automatically get back to his seat now that he has been acquitted. The provisions regarding a disqualification in the statute are as follows. Article 102 of the Indian Constitution lays down provisions of disqualification. The essential grounds are holding an office of profit, being of unsound mind or insolvent, or not being a citizen of India. The Representation of the People's Act 1951 provides that a person will be disqualified if convicted and sentenced to imprisonment for 2 years or more. The disqualification remains for 6 more years after the term of imprisonment. In the case of K. Prabhakaran versus P. Jayarajan in the year 2005, the court held that in case of a disqualified candidate who is later acquitted, the disqualification would be removed with retrospective effect. In a very prominent case by the Honorable Supreme Court is Lily Thomas in the year 2013, it was stated that a disqualified person may obtain a stay on his conviction and then contest elections. The question that now arises is that whether he should be reinstated as if the removal never happened, or whether the vacant seat is to be filled with by a by-election. Coming up to the news update of the today's session, first, national level Hackathon Kavach 2023 launch. It will identify innovative ideas and technological solutions for addressing the cybersecurity and cybercrime challenges of the 21st century. Secondly, Ramesh Bias took oath as Maharashtra governor. Guys, recently we discussed that for the state of Sikkim also, there is a newly appointed governor. Please do let me know in the comment section who is the governor of Sikkim. Acting Chief Justice of Bombay High Court, Justice Sanjay Gangapurwala, administered the oath of office and secrecy to Mr. Bias at Raj Bhavan in Mumbai. Coming up to the third news update, Lieutenant General Mr. M.V. Suchindra Kumar is new Army Vice Chief. Lieutenant General Mr. M.V. Suchindra Kumar is the new Vice Chief of Army Staff. Lieutenant General Kumar replaces Lieutenant General B.S. Raju, who has been appointed as the Jaipur headquartered Southwestern Command Chief. Bharat Electronics Limited to manufacture Israel's LoRa ballistic missile for India Trial Services. The state-of-the-art strategic weapon system will be manufactured by Bharat Electronics Limited as the prime contractor based on the work-share arrangement with IAI. Fifthly, Tourism Ministry to organize first Global Tourism Investors Summit. The event will showcase investable projects and opportunities in tourism and hospitality sector in India to domestic and international investors. Sixthly, Hindustan Unilever Limited to sell Annapurna and Captain Cook brands. With this, HUL will exit from non-core atta and salt business. Coming up to the legal updates. Challenge under Section 13 of Arbitration Act not raised. Party can challenge unilateral appointment of arbitrator under Section 34 by Honorable Madras High Court in the case of Hina Suneet Sharma and another versus Messrs. Nissan Renault Financial Services India Private Limited. Even if a party has failed to challenge the unilateral appointment of the arbitrator under Section 30 of the Arbitration and Conciliation Act 1996, before the arbitral tribunal, it would not take away its right to challenge the award under Section 34 of the Arbitration and Conciliation Act on the ground that arbitrator was unilaterally appointed. Coming up to the next legal update, Section 52A of the Narcotic Drug and Psychopathic Substances Act not barred to grant interim custody of seized vehicles under Section 457 Criminal Procedure Code by Honorable Kerala High Court in the case of Shaneen versus State of Kerala and other connected matters. Jurisdictional courts such as the Special Court and Magistrate Court are already vested with the power to grant an interim custody of vehicle seized in connection with offences under the Narcotic Drugs and Psychotropic Substances Act under Section 457 CRPC, irrespective of the procedure for disposal stipulated in Section 52A of the Act. That's all for the today's news session. Stay tuned and take care.